The next matter that comes before court this morning is Deutsche Bank versus Marlene Brown. As you know, each party will have 15 minutes to present oral argument. The appellant proceeds first and may reserve up to 5 minutes for rebuttal. We've read the briefs and we're prepared to proceed. Mr. Sanders?
Yes, thank you, Your Honor. Your Honor, let me approach the bench. I have a couple of exhibits that are going to be frequently referred to in oral argument. I was just going to provide the court to make it a little easier.
Were they admitted during trial?
Yes, yes.
Did you show them or have you
Yes,
shown them?
He has, Your Honor. I have no objections.
Okay, that's fine.
Thank you.
Thank you.
All right, I'd like to reserve 4 minutes for rebuttal.
Okay.
May it please the court, counsel. My name is Greg Sain, and I'm here on behalf of the homeowner, Marlene Brown. In order to simplify things, I'll be referring to my client as Ms. Brown and to the appellee Deutsche Bank as the lender. Ms. Brown will be addressing the issue of acceleration today. Although there are a couple of quick comments on the local rule assignment of error. In appellee's brief, it was they quoted the July 1, 2015 amended rule, civil rule for Rule 56, and not the civil rule that actually applies to this case. The version of Rule 56C that applies to this case, we believe any additional right to reply created by the local rule should be equally given and equally applied to both parties under the version of the rule at that time. We also believe that the rule should have been liberally applied to allow us to file a surreply. The primary issue for today, though, is that Ms. Brown would like to address the summary judgment evidence demonstrating that whether the mortgage loan was properly accelerated. The only lender evidence produced for demonstrating compliance with mortgage paragraph 22 was the July 15, 2014 letter to Ms. Brown, which I provided to the court. In summary judgment proceedings, as a non-movement, Ms. Brown is entitled to the benefit of the doubt and all presumptions and inferences in her favor. Ms. Brown believes that for Rule 56 summary judgment purposes, the July 15 letter fails to demonstrate compliance with paragraph 22 of the mortgage, which I've also provided. It is important to note that the July 15 letter must complement and be read in conjunction with mortgage paragraph 22. The letter cannot create independent rights for granting acceleration. The decision whether or not to accelerate is optional with the lender. When the lender decides it wants to accelerate, paragraph 22 tells the lender what to do. Paragraph 22 requires the lender to specify for the homeowner the default and what the homeowner must do to cure the default in order to avoid acceleration. Paragraph 22 calls for specificity, so the homeowner knows clearly and exactly what must be done by the deadline stated. By requiring the notice to specify, that is to state clearly and exactly the default and what must be done to cure the default, paragraph 22, properly applied, simplifies the matter of acceleration for both the lender and the homeowner. In other words, a properly drafted paragraph 22 letter works for the benefit of both parties. In the following respects, the July 15th letter complies with paragraph 22 when it specifically states, to cure the default, you must pay the total delinquency against your account, then itemizing the specific amount of the total delinquency. In a manner consistent with paragraph 22, the letter then specifically states to avoid the possibility of acceleration, you must pay this amount, again, the amount of the total delinquency, on or before August 19, 2014. So I'm just quickly referencing the letters that I provided. The to cure the default language then specifies the amount. The sentence then that follows talks about to avoid the possibility of acceleration and then goes on to state by the date certain. So in that respect, it's very specific. After that, it tends to break down. So in other words, these initial statements meet the specificity required in paragraph 22. They state clearly and exactly the default and the action required to cure the default. However, the lender goes on to say, and then that would be in the next sentence following, the lender goes on to say that it can include the failure to make the payment for August, plus any late charges and other charges that may also be made a matter of acceleration. The sentence which follows the above sentences does not refer to future payments, the August payment for purposes of this case, that becomes due during the 30-day period of the July 15th notice. I'm sorry, this sentence does refer to future payments, the August payment. However, this following sentence, in other words, this second sentence, unlike the two prior sentences, does not speak to acceleration. What it says is, it says, for the loan to be current and not in default, any additional monthly payments, late charges, and other charges that may be due after the date of this notice must also be paid. There's no question that this is a statement of what needs to be done to keep the loan current and not in default. However, keeping the loan current and not in default is not the same as acceleration. Unless specifically linked, default and acceleration are two different separate concepts. Default is a condition for acceleration, but default itself is not itself acceleration. It stands alone unless it is linked to acceleration. Unlike the prior sentences, this following sentence does not directly link the failure to make the August payment or other future charges with acceleration. Unlike the prior sentences, and contrary to paragraph 22, this sentence does not specify that this is the action required to cure the default in order to avoid acceleration. Following the above sentences, there's an additional sentence that states, and I'm referencing this sentence here, if the funds are not received by the above referenced date, we will proceed with acceleration. Initially, this sentence does not specify the funds to which it is referring. The only specified amount linked to acceleration in the prior sentences are the sentences specifically stating what must be done to cure the default. These two initial sentences, those are the only sentences specifically linked to acceleration. As discussed, the sentence following these sentences merely states, this following sentence merely states what it will take to keep the account current and not in default. This is good information, but is not linked to acceleration, as with the prior sentences. It must be kept in mind that paragraph 22 requires the notice to specify, that is, state clearly and exactly what must be done to avoid acceleration. This sentence does not do that. The lack of clearly stated direct link is in contrast to the Moore case cited by the lender in its brief at paragraphs 12 and 13. In the Moore case, at paragraph 30, the acceleration letter made the direct link between acceleration and both the past and future payments. In that case, the notice stated, to avoid the possibility of acceleration, you must pay this amount, the amount of the default, plus any additional monthly payments that may become due after the date of this notice. Contrary to the July 15th letter in our case, this statement in the Moore case is clear and unambiguous. It is also worth noting that the fact that the sentence in our case, the sentence applying to the future August payment, is drafted in a way that speaks to what it will take to keep the account current and default without expressing a specific intent to accelerate, may in fact be in recognition of the fact that paragraph 22 requires written 30-day notice following any default.
Let me ask you a question. How is the lender supposed to know what day Ms. Brown would pay the $95,264.85?
They don't.
So it's in her control as to whether or not there's going to be a delinquency on that August payment as well, right?
Well, and that gets to whether August was properly demanded. In other words, if you look at...
It couldn't be because it wasn't due yet.
Pardon?
It couldn't be because it wasn't due on July 15th.
Correct. In paragraph 22, in terms of acceleration, and under the express terms of paragraph 22 only applies to existing default. It does not apply to what may occur in the future.
Right.
In other words, the whole idea of it is designed to say, okay, this is what's due, this is what you need to do to bring it current. It's not really designed to get into, for acceleration purposes, what might happen in the future. because that can get too speculative, in terms of late charges, other charges. That's kind of the whole idea. The whole idea of this is to make it very specific, so everybody kind of knows what you need to do, at least to avoid acceleration.
And that was included, that information was included, correct? In a specific way. What you're arguing is that, in a sense, there's too much information.
Correct. I think that in a sense, let's put it this way, it tells you the status of the account, which is good, but it certainly doesn't mean that that's what you need to do to pay that August payment, plus other late charges, et cetera, to avoid acceleration. Because paragraph 22, when you read paragraph 22, what it says is, it says, in paragraph 22, to quote it, it says, you must give notice to the borrower prior to acceleration following borrower's breach of any covenant or agreement. So in other words, the notice requirement is triggered when a breach has occurred, not when it's about to occur. It's triggered when it's occurred. That's the whole point of it. It's to make it really clear to everybody what needs to be done right now to avoid acceleration. That is the purpose of it. That's what that's the contract language. They're trying to enforce the contract against my client. They need to abide by the contract. I mean, they have that obligation also. This is what the contract says. We're simply asking the court to enforce what the contract says. We're not asking for any special consideration here. We're asking the court simply to apply the contract and the contract language as it is stated.
You're approaching 4 minutes, so you can continue if you like, or is there...
I will reserve the 4 minutes. Thank you.
Good morning, may it please the court. My name is Scott King. I represent Deutsche Bank National Trust Company. Deutsche Bank asked the court to affirm. This case, at least in the briefing, presented two primary issues. Number one, whether the trial court erred in failing to afford Ms. Brown a leave to file a reply memorandum, or actually a reply memorandum in support of the motion for summary judgment. And number two, was there any problem with the notice of default? The answer to both of those questions is no, and I'm going to address them in that order. First issue, first assignment of error, asserts that Local Rule 7.14C is unconstitutional because it does not afford an opponent of a motion for summary judgment the right to file a cert reply. That has no merit. As Mr. Sain noted, in July 2015, the General Assembly, the Ohio Supreme Court amended Rule 56 to expressly provide the time periods for filing a memorandum in opposition and a reply memorandum for a motion for summary judgment. Prior to that, the timing of the memoranda was controlled by local rule. Rule 56 has never, before or after amendment, provided the right to a cert reply. So if there is a constitutional right to a cert reply, not only would Local Rule 7.14 be unconstitutional, so would Rule 56. But it wouldn't end there. Under our jurisprudence, the right to open and close an argument is always given to the party who has the burden of persuasion. 2315.01, the right to open and close evidence at trial is with the party who has the burden. The right on closing argument is with the party who has the burden. Your Honors, in this court, the same procedure applies. Rule 16 says the appellant who has the burden has the right to open and close the argument. In this very argument, Rule 21D says that the right to open and close is with the appellant because the appellant has the burden of proof. There is no constitutional right to file a cert reply. That notion is antithetical to our jurisprudence. The first assignment of error has no merit. The second assignment of error alleged that there was an abuse of discretion in failing to grant leave for a cert reply. There was not. The motion for cert reply didn't identify any new arguments that had not already been addressed in the memo and op. And to the extent that there were any new arguments, they were already included in the motion itself for leave to file a cert reply. There was no abuse of discretion in the implicit denial of the motion to file a cert reply. Now I'm going to get to the meat of what we just got done talking about, which is the notice of acceleration. We are in agreement. The mortgage requires a notice that says 4 things. what the default is, how do you cure the default, a time period more than 30 days after the date of the notice to cure, and a statement that says that if you don't cure, there may be acceleration. This notice mirrors each one of those 4 requirements. It states that the failure, the breach was the failure to make payments. It states that the amount due is $95,263.85. It states a date more than 30 days, namely August 16th, 2014, August 19th, 2014, to make the payment, and it expressly states that to avoid acceleration, you must pay this amount. There's no question that this letter contains all 4 of those requirements. The only issue that's been raised is the effect of the additional sentence. And the issue is whether the additional sentence somehow nullifies the 4 clear requirements. With respect, it does not, for 3 reasons. Reason number 1, the mortgage required monthly payments. However, Section 22 requires the notice to give at least 30 days. So there's a truism here that if I'm going to be more than 30 days, there's always going to be another payment due if you wait till the end of 30 days. This sentence simply recognizes that truism. It doesn't condition acceleration on the payment of the next month's payment. It just says, look, this is more than 30 days later. To be current, you have to continue to make your payments. Reason number 2, and Judge Schaefer hit it right on point. There's no control over when the borrower makes the payment. If, in fact, the borrower makes the payment the next day, then there is no obligation immediately to pay the next month's payment. So it recognizes the reality that we don't have any control over when if the cure is to be made. Reason number 3, Your Honor, as a practical matter, this loan is in default for 2008. Ms. Brown owes $95,000. She didn't tender any money. This is not a case where the lender said, in order to cure, you need to pay X. The lender pays X, and the lender says, oh, no, you need to pay X plus something else. In this case, there was no attempt to tender at all. This is, with respect, all a red herring. This notice complies with Section 22 of the mortgage. The additional information is for the assistance of the borrower. There's nothing wrong with providing that additional information. For all these reasons, this 3rd assignment of error should be overruled. The 4th assignment of error addressed the issue of whether the affidavit needed to say true and accurate in front of the word copies. The reply brief, I think, withdrew that assignment of error, but just for the sake of completeness, the affidavit satisfied the requirements of Rule 56. Rule 56 requires sworn copies. There were sworn copies appended to this affidavit. Adding the words true and accurate is not found in Rule 56, and as pointed out in the briefing, with respect, it's an abuse of the English language. Adding the words true and accurate to the word copy is an exercise in redundancy. It's like saying an armed gunman or a free gift or something is the exact same as the other. It's simply redundant. This affidavit complied with Rule 56. The trial court, Your Honor, got it correct. At some point, all litigation must come to an end. This loan is past due for 7 years. The trial court's decision was correct and should be affirmed. And with that, Your Honors, unless there's any questions, I'm going to conclude. Thank you very much.
Mr. Sane, you have a little over 4 minutes remaining.
Okay, thank you.
Before you begin, or as you begin, would you address the statement of Mr. King that 4th assignment of error may have been withdrawn?
Yes, Your Honor. We did indicate that we're going to withdraw that one.
Very well.
Yes, as far on the issue of acceleration, I'd like to just briefly address what's been stated. I guess, initially, the fact that the loan's in default since 2008 does not change the requirements of the contract. I mean, the contract says what must be done to accelerate, whether the lender chose to accelerate, when they choose to accelerate, that's up to them. In other words, the homeowner doesn't choose when acceleration occurs. The lender chooses when acceleration occurs, but it only happens when the lender complies with paragraph 22. I mean, that is what is required by contract. So In essence, I think at least asking for the contract to be rewritten, and as we know that can't be done. We're simply asking, we're not asking for special treatment, we're simply asking for the contract to be enforced on its specific terms. As far as the fact that there will always be a future payment due, potentially within the 30-day periods of a notice of default, that to me, in essence, is a red herring. That has nothing to do with acceleration. That's mixing default and acceleration. Default is default. Default is a standalone. Acceleration is a different concept. Acceleration means that, okay, in light of this default, we are now going to accelerate. The contract permits that, but it only permits it as specified in paragraph 22. And paragraph 22 only applies to existing defaults. As it specifically states, the notice of terminate or the notice of default and acceleration will apply to let me get the specific terminology, but in the very first sentence, will give notice to the borrower prior to acceleration following borrower's breach of any covenant. It's something that has to have already occurred. It's not something that may occur in the future. So in that sense, the reference to the August, that's fine, that's good information, but by the express terms of paragraph 22, it's not a condition for acceleration. It can be if another notice is served, but at the moment that notice of acceleration is served, it's known what the charges are. And in fact, they specified those charges in their letter, so everybody knew that this amount needed to be paid by that date.
So are you saying they can never accelerate because that next payment?
They can't accelerate based on that. They can accelerate based on the failure to pay the amount specified. Yeah, I mean, if she didn't pay this by that date, they can definitely accelerate. It's just that you can't then add on to that something that's going to happen in the future.
Well, wouldn't they have to do that then? Because there's no breach until it occurs, so they have to do that in the future then? Because it says may.
No, because that would be contrary to what the contract says. The contract says nothing about that. The contract specifically says that notice of default following a breach. You can't have something in the future and say that that's following a breach. It's not following a breach. And if the contract says following a breach, a notice in terms of acceleration will be served. Again, I think that what's happening here is they're trying to link acceleration with default as if it's automatic. It's not automatic. Default is a standalone. Acceleration only occurs upon service of the proper notice. Once that happens, based on an existing default that everybody is specific on, again, this is to save somebody's home. The idea, and to avoid acceleration. So the idea here is to give a specific amount, a date certain, so the homeowner can avoid the problem. That is what this is about. It's not asking the homeowner to kind of guess in the future. I mean, August payment, that's pretty clear. But what about late charges? What if the homeowner says, I paid it on time? The lender says, no, you didn't. What about other charges? Some sort of inspection fee. That's not in the letter. That's not specificity.
And Mr. Singh, unfortunately, you've reached the end of your time.
All right, thank you.
You're welcome.
Thank you.
Thank you both for your presentation. We'll take the matter under advisement, issue a written opinion, which will be sent to our parties, and certainly you can check with the Supreme Court website. Have a good day, gentlemen.
Thank you.
Thank you.